system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice.
morning, everyone. You may be
Morning,
seated.
Your Honor.
All right, any matters we need to get on the record on behalf of the state? No, Your Honor. Thank you. On behalf of the defendant?
No, Your Honor.
Mrs. Harper? Yeah, okay. I didn't connect.
All rise for the jury.
You may be seated, ladies and gentlemen. Good morning, everyone. Welcome back to Courtroom 4B. We will continue with the defense presentation of its evidence. You may call your next witness.
Thank you, Your Honor. The defense calls Mr. James Scanlon to the stand.
Good morning. Please raise your right hand. Do you swear or affirm that the testimony that you're about to give is the truth, the the whole truth and nothing but the truth, as you shall answer unto God, under the pains and penalties of perjury?
I do.
You may be seated. It's important that you speak into the mic so that the ladies and gentlemen of the jury can hear you.
Yes, sir.
It's also important that you respond verbally. Sometimes it's difficult to interpret.
Yes, Your Honor.
If you would, for the record, state your name, spelling your last.
James J. Scanlon, Scanlon.
Thank you. You may inquire.
Thank you very much, Your Honor. Good morning, sir.
Morning.
Mr. Scanlon, could you please introduce yourself to the ladies and gentlemen of the jury and tell them a little bit about yourself?
Yeah, my name's Jim Scanlon. I grew up on the east side of Columbus and graduated from Bishop Hartley High School. Later, I graduated from Ohio Dominican College with a degree in criminal justice. I've been married for 48 years to a great lady. Got 2 grown children and 3 grandchildren.
How is it being a grandparent?
I love it. It's the best job I've ever had. I love police work, but yeah, that beats it.
Sir, after high school, what did you do?
I worked for my dad for a while. He had a tire company. I ultimately joined the Columbus Division of Police in 1978.
In order to join the Columbus Division of Police, tell the ladies and gentlemen of the jury what you had to do.
Yeah, there's a hiring process, so there's a test. It's both, you take a written test, you take a physical test back then, and then you end up going through a background test and polygraph and all the stuff that they do to kind of vet you. It's a long process. I think I started the process in 1977. I was hired in April of 1978.
Okay. Prior to being hired, you go through an academy.
Yes, well, we're hired and paid to go through the academy. It's about a 6-month-long process.
Okay, and what do you learn in that academy, sir?
It's OPATA driven, so the Ohio Peace Officers Training Academy dictates what courses you'll take, a curriculum, and they mandate a certain number of hours, and the Columbus Division of Police then increases that number of hours and gives you courses beyond what the Ohio Peace Officers Training Academy would require.
Right. And you started in what capacity as a Columbus police officer, sir?
Started off in Patrol Bureau.
Okay. How long were you on patrol?
8 years.
Okay. Briefly, if you can, tell the ladies and gentlemen of the jury some of the duties with regards to patrol officers.
Yeah, so a uniformed patrol officer would just respond to normal calls for duty. Of course, you'd be engaged in traffic situations. You would be dispatched to everything from just a normal disturbance on up to a homicide. You just never knew for sure what you were going to get into, but you just basically did that. I did that on second shift hours, like a 3P to 11P, as well as a late mid-watch, which was a 7P to 3A type hours.
Well, how long were you a Columbus police officer for, sir?
Total of 33 years.
Okay. Part of those 33 years, what other assignments did you have as a Columbus police officer?
I spent 6 years on our K-9 unit, and I spent 19 years on our full-time SWAT section.
Okay. In those different sections, patrol, K-9, SWAT, did you also, were you also a training officer?
I was. So I did that in patrol. After about 2 years on the street, I became a field training officer who basically takes an officer as they exit the academy and for at least 1 month. Normally it's more now, but I would have an officer and basically show them how to apply what they learned in the academy to actual street situations.
Did you do the same, well, you were a training officer both for then the K-9 unit and then again in the SWAT team?
That's right. So in K-9, I was an in-service training officer, so I would coordinate and conduct training on a weekly basis with our K-9 team. And then in SWAT, I was part of the training function group within that. And so we would coordinate training for our own unit as well as others within the Columbus Division of Police and others throughout the state of Ohio.
Okay. And when you are training, is there a component of use of force in aspect both on patrol, K-9, as well as SWAT?
Yes, and so they're all the same, but you talk about the use of force and deadly force in many of the different tactical training scenarios that we would present in patrol, K-9, and SWAT as well, because you wanted officers, as you're doing training, especially in situations that might involve a use of force or deadly force. You want them to know what the standard is, and you want them to know what to expect when that happens.
Okay. And so you've trained people on those standards?
I have.
How many would you say?
It's a component within everything. I trained within the Columbus Division of Police, as well as a company I had, North American SWAT Training Association, so we incorporated that. Thousands of officers, I would guess.
Here in Columbus?
Here in Columbus, throughout the state of Ohio, throughout the United States, and beyond.
Okay. When you say beyond, what do you mean by that, sir?
Well, I started a company in 1999. I was still on the police department, but we started, myself and 3 others, started a company called North American SWAT Training Association, NASTA for short. And what we did is provided training to police and military personnel throughout the United States and beyond. And so we trained pretty much in every state in the United States. We had a lot of training that was centered here, where people would come here from around the United States, other countries, Germany, Australia, different places, and then we would conduct training other places as well.
And again, sir, is a component of use of force part of those training aspects?
We always included that. Yes, we did.
Okay. And did you continue your training while you were a Columbus police officer?
I did, yes.
In all segments?
In all segments, yeah. We were constantly receiving in-service training in every aspect of every assignment I had from a number of different agencies.
Based on your training, sir, and the training to do the others, give the jury a brief description of what you believe reasonable suspicion means for an officer to investigate.
Reasonable suspicion would be indicators. It would be some suspicion, some indication that there is either a crime has either taken place, is taking place, or is about to take place. It's enough reason to make contact with somebody and to inquire as to what they're doing. And now, it's not enough to arrest somebody. That would be probable cause. So once you have reasonable suspicion, you can inquire. It may turn into probable cause to where you can make an arrest. Reasonable suspicion is just that, just basically suspicion.
Suspicion of a sneeze, correct? So, did you use that on your patrol duties?
Oh, absolutely, yes.
Just because you have reasonable suspicion something might be going on, does that mean it has to be going on?
Oh, no. Sometimes it turns out to be there is something going on, and sometimes you inquire to the person who's displaying suspicious activity, and they have a perfectly logical reason for that, and you say, okay, fine, have a nice day.
Okay, all right. As part of your responsibilities as a Columbus police officer, were you also part of the officer support team?
I was.
For how long, sir?
About 20 years.
Describe for the ladies and gentlemen of the jury what that is.
Yeah, so officer support team was developed kind of early on in my career, and at the advice of professionals, psychologists, administrators, who recognized that officers are often thrown into situations where there's a lot of trauma. It can be a police-involved shooting, or it can be responding to a scene where maybe a child has died. It can be the fact that maybe a police officer has been shot and killed in the line of duty. There's so many different traumas that police officers and medics go through that they developed a group of people that could respond to that based on the fact that maybe they've been in those kind of situations before. The professionals agreed that if you can get to a person who's been through that kind of a trauma quickly and at least advise them as to what your experience was initially, they may be able to survive that emotionally in the years to come. But if you don't do that, they just become another casualty, like we've seen so many times in these kind of situations where they don't get that kind of mentoring or counseling.
Have you responded to those types of scenes?
I have responded to dozens of those, yes.
Based on experience that you went through?
Yes, sir.
During your career as a Columbus police officer, did you receive any awards?
I've been lucky to receive some awards, yes, I have.
Mr. Scanlon, I see from your CV you received 7 hierarchy commendations from the hierarchy 6 times. I apologize. Tell the ladies and gentlemen of the jury what that is.
Yeah, the special commendations, they're just for, in my case, it was, there were some on view, robbery, arrest, on view, rape, apprehensions, and I helped create the K-9 unit, so things like that would be your special commendation award.
You've also won a couple Civil Star Awards, correct?
I have.
What does that mean for ladies and gentlemen of the jury?
Yeah, that's a pretty high award. That's one where you've probably been engaged in some kind of life-saving effort. I was lucky enough to respond to a cell tower one time where a female was going to jump off. She pushed off, and we were both lucky. I was just able to hold on to her.
It's for above and beyond the duty?
It is.
How about a Blue Star Award? You won one of those.
That's for an injury in the line of duty.
How about a Medal of Merit?
Again, I got one of those for an investigation and apprehension of a child rapist.
You've won all those awards as a Columbus police officer.
I have.
With regards to, have you won any national awards as regards to a Columbus police officer?
Yes, once. There's the International Association of Chiefs of Police Award, 10 officers each year, the top 10 award. And myself, and probably more based on my partner, Chris Hauser, we were lucky enough to Chris Hauser, Hauser. We were able to secure 2 of those slots one year.
Have you had extensive personal training in law enforcement concepts?
I have.
Have you trained others in those concepts?
I have.
Have you written any articles on law enforcement concepts and use of force?
I have. Not solely on use of force, but it encompassed use of force. Well, articles I wrote about tactical situations, response to active threat or active shooter, SWAT situations and such.
Have you presented on use of force concepts, Mr. Scanlon?
I've presented on different tactical situations where the subject of use of force or deadly force came up.
Have you testified as an expert in use of force cases, sir?
I have.
Okay. Had you testified in State v. White in this state?
I did.
Tell the ladies and gentlemen jury what that means with regards to State v. White. How's that relevant to the state of Ohio?
Well, it became a Supreme Court issue in Ohio, and they basically set a mandate for Ohio that the Graham v. Connor objective reasonableness standard would be applied to cases in Ohio, whether they be civil or criminal in nature.
And you testified that in 2009?
I believe the incident happened maybe 2009. I testified either 2009 or 2010.
Have you been declared an expert in Franklin County Common Pleas Court on use of force cases?
I have.
Have you been declared an expert in other parts of the state in common pleas or municipal court as a use of force expert?
I have.
Have you been declared an expert in use of force in federal court?
Yes, I have.
What districts? Or what area?
Both a southern and northern district, I believe.
Of Ohio?
Yes, of Ohio.
Okay, all right. Your Honor, at this time, I move the court to declare Mr. Scanlon as an expert on use of force cases.
No objection, Your Honor.
The record shall so reflect.
Mr. Scanlon, I want to kind of change gears here and talk about your methodology or your process when you're deciding to take a case. How does that normally happen? What do you normally do? How do you normally become involved, I guess?
Well, normally I get a call from an attorney. It could be on a civil case, a lawsuit or such, or it could be a criminal case. And the attorney will ask me if I can help them in this case. They give me a little bit of information about that case, and then I normally say, well, I'd like some documents just to determine whether or not I want to get involved in it. They'll send me maybe a body-worn camera video. They'll send me maybe a statement or a complaint, maybe a investigative summary, something to that effect. And then I'll go through that and I'll decide whether or not I want to get involved in the case. Now, I don't get involved in many. I don't take what I consider to be close call cases. I take less than 30% of the cases I'm asked to take. So if I do decide that, yes, I can get involved in this case, or I will, I'll call the attorney back. I say, I think I can, but understand this, once I go through all the information, the totality of the circumstances in this, my mind may change. And it has changed at times. But they will then send me the entire.
So you're contacted by an attorney, could be a plaintiff's attorney or defense attorney in civil cases?
Yes, sir.
Have you been contacted by both of those types?
I have.
Then you can be contacted by prosecutors or defense attorneys in criminal cases?
Yes.
Okay. And in situations, then you get a basic review. Is that fair?
I do a real preliminary review, yes.
At that point, you then indicate whether or not you want to move forward or not.
That's correct.
Have I given you cases to review?
You have.
And have you sometimes, or I'm sorry, what have you done sometimes when I've given you cases?
I believe I've turned you down more times than I've accepted.
And you mentioned something, I think you just said, you decide to get involved in a case. Are there other aspects that go into that, sir, or just your personal beliefs, or you tell?
I have the option to turn down a case, even if I think they have a good case and they want me to testify in that case. If I don't feel good about the totality of it or other aspects of it, I turn it down. I'm not saying, when I turn it down, I'm not necessarily saying that they don't have a good case. I'm just saying I don't want to be involved in it for whatever reason.
So have you formed an opinion at that initial preliminary step of reviewing basic material?
Just a preliminary idea of where I think I'm leaning, understanding the fact that it may change once I go through all the materials.
So then you say that to an attorney. So in this situation, you said that to me and I sent you everything, correct?
Yes.
Okay. And when you, is that the same process you've done in every other case you've become involved in?
It is.
Okay. You mentioned that after you review everything, you may have a difference of opinion than you did initially.
That's correct.
Has that happened before?
It's happened at least 2 or 3 times that I can think of, yes.
And with regards to then, what's the next step, sir, after the entire evidence you've had a chance to review? Do you then contact the attorney?
I do. Now, as I'm reviewing that information, of course, I have a mandate on how to review it. It involves, I have to abide by the only standard by which officers are judged.
And what is that standard, sir?
It's the Graham objective reasonableness standard, where I have to put myself in the shoes of a reasonable officer on scene. And I have to acknowledge all of the conditions that the U.S. Supreme Court and the state Supreme Court presented basically anybody who's going to be in review of this type of case.
Once you're done with that, you then contact the attorney and you tell them what?
I tell them I've been through all the information and my opinion has either not changed or it has changed.
Okay. What's the next step in the process in general?
I normally write a report to be given to the requesting attorney.
Okay. And in this situation, let's turn to here. In this analysis, I contacted you.
That's correct.
Gave you some basic information.
Yes, sir.
You indicated you might be able to work with us.
Yes.
Then I gave you all the discovery, correct? Or that we had.
Yes.
And and then then I asked you to write a report, I asked you to write a report.
Yes, sir.
All right. And when you're coming to your opinion, you mentioned you have to consider the totality of the circumstances. What does that mean for the ladies and gentlemen of the jury?
I review every single piece of evidence, discovery, materials that's sent to me. And I have to do it, again, through the eyes of a reasonable officer on scene rather than the 20/20 hindsight I might have in the luxury of my office. And so I review all of it. It's all the materials. I go through all of it. It's all relevant to me. Some of it's more relevant than other pieces of evidence, but I go through it all.
So you mentioned something there, not hindsight. So do you review what someone should have done or could have done?
No, I'm prohibited from considering that because that was expressly prohibited by the Supreme Court courts as they handed down the standard.
Okay. With regards to, is it what a reasonable officer could have believed about the need to use deadly force? Is that the standard?
It's what a reasonable officer on scene would believe and would perceive as a threat.
Okay.
And it's a perceived threat. It can be an actual threat. It can be a perceived threat.
Well, explain what you mean by an actual threat versus a perceived threat, Mr. Scanlon.
Well, the courts acknowledge the fact that officers can be mistaken as to what's in someone's hand, or not even in somebody's hand. I mean, it can be a case of, the way the hand is presented in some situation is as relevant as what's in it, maybe more so, but it's how it's presented. So it can be, they acknowledge the fact that officers can be mistaken in their reasonable belief, but it has to be reasonable.
That would be a perceived deadly threat.
Yes.
Versus an actual deadly threat of someone shooting.
That's correct.
Now, in this situation, did you, the materials that you reviewed, did you review the indictment?
I did.
Did you review the BCI initial briefing?
Yes.
The search warrants in this case?
Yes.
The written statement by Mr. Coy?
Yes.
The interview by Mr. Coy?
Yes.
The prosecutor's package?
Yes.
The case cover sheet, the party list, the file list, evidence list, BCI initial response, CAD records, and did you review those?
Yes.
Did you also review the building, the searches, the room clearing?
I did.
Did you review the dealing with the aftermath of the shooting?
Yes.
Did you review tactical firearm techniques and shoot, don't shoot scenarios?
Yes.
Okay. And you reviewed body-worn camera and things of that nature as well, correct?
Yes, sir.
Crime scene evidence,
Yes, sir.
crime scene photos,
Yes.
labs,
Yes.
witness interviews,
Yes.
coroner's report,
Yes.
any videos or package list or anything of that, correct?
That's correct.
Okay. The vehicle in question here,
Photos and items in, yes.
the leads printout with the tag that was run?
Yes.
Okay, a complete analysis of all the information, correct?
As far as I know, it's the complete discovery evidence that was provided. Yes.
Did you visit the scene in your analysis?
I did.
Why do you go to the scene, sir?
When possible, and I try to make a point of it. I'm pretty visual. I like to, before I make a decision, I like to put my eyes on it. It's one thing looking at photos of a place, photos of a car, photos of a residence, but to actually go there and look at it, for me anyway, helps me come to a better, I think, decision. So I wanted to see 1054, Oberlin, 1062, 1070. I wanted to see both driveways of 1070 and 1062. It helped me understand that the brush and the trees that were between both driveways. It also helped me understand better the fact that the garage to 1062 is actually inset and bordered by walls on 1062 and 1070 that would kind of pin you in. It just appeared differently than what I expected it to be. So it was helpful to me in coming up with a decision.
So visiting a scene sometimes gives you different perspectives than looking at photographs.
It does me.
Okay. Now, after reviewing all of the information, did you come to a conclusion whether or not Mr. Coy's actions were in accordance with recognized police training and techniques?
I did.
And that conclusion is what, sir?
Yeah, in my opinion, the actions of Adam Coy were consistent with federal and state law enforcement standards and training and practices.
Okay. I want to talk about some police concepts briefly, okay? The police concepts I'm talking about, I'm sorry, do police concepts come from case law from the Supreme Court in police officer involved uses of force?
They're addressed. It comes from our training, too.
Okay. I want to talk about an action versus a reaction, okay? Explain to the ladies and gentlemen of the jury that police term.
Yeah, action beats reaction is a concept that every police officer I have ever been involved in knows the idea of, but they're trained from the academy on about this. We do it in all our training and always have. But the concept is the actions of a subject will be faster than the officer's reaction to that. And so it's just a fact. You're always playing catch up. The way I was trained and the way I tried to impart training to others, I would enlist the help of an individual who trained fighter pilots for the Navy. And he utilized this thing called the OODA loop.
What is OODA loop, sir?
Yeah, so it's OODA. So the first O stands for observe. The second for orient yourself to that. The third is, the D is for decide, and the A is for action. So the best way I can explain it to you is on your way into the courthouse today, if you're driving, and you have somebody in front of you who hits the brakes hard, you have to observe that. And then you have to orient yourself to that. What's that mean for you? Are you too close? Are you going to have to do something drastic, or are you further back and it's going to be not so relevant to you? But you have to observe and orient yourself to that. Then you have to decide on an action. And maybe that action is nothing. Maybe you need to do nothing. Maybe you need to hit the brakes hard. Maybe you need to swerve. And then you have to act upon that decision. And all that does is put you back to the first O, which is observe, to see how that changed things for you or didn't. But the point is, it takes a while to get through that OODA loop. You do it every single day on different things. But for an officer, it's very important because it can be, you can be up against a serious threat. And if you hesitate, and if you don't get through that OODA loop fast, and if you don't react to a perceived threat, then you die, or the person you're trying to protect dies. And so it's very, very important for officers to understand the fact that action beats reaction.
Okay. And officers are trained on that?
Yes.
Okay. And because of that, based on the case law, do officers have to wait to use deadly force if force is used on, do they have to wait to force to be used on them first before they use deadly force?
No, they're actually trained to do the opposite. You can't wait until that force is used upon you. You have to react to that threat, whether it be perceived. But if it's a reasonably perceived threat, you must react to it. And that's how they're trained, every officer in the country.
And in fact, the Supreme Court of the United States indicated that an officer need not wait to see the glint of the steel.
They did.
And is that the concept you're talking about?
It is exactly that concept.
Okay. You talked about an actual threat may be a knife or a gun, don't know if the gun's loaded, versus a perceived threat, correct?
That's correct.
Is there any difference in dealing with a perceived deadly threat versus an actual deadly threat?
No, you have to react to both.
Okay. Is actual possession of a gun relevant in your analysis if the officer reasonably believed the individual possessed a weapon?
No.
Why not, sir?
The only relevancy here is whether or not the perceived threat of the officer itself is reasonable.
What can be examples of perceived deadly threats, sir?
Oh, it can be just a presentation, again, getting back presentation of a hand. You can, an individual can have their hand behind them and quickly bring the hand up. They can have it in a pocket and quickly bring it out. They can have something in their hand that's other than a knife or a gun that is perceived as a knife or a gun.
This isn't a vacuum, is it? It has to, it's based on the totality of the circumstance, your analysis, correct?
That's exactly right. So it starts really it's based largely on what's in the mind of the officer on scene. So, you know, that whole scenario starts when they're dispatched to a run. Mm-hmm. And then once they arrive at the scene, and then once they encounter an individual, and then what that individual does or doesn't do. And so it's just a building of different situations that kind of culminates in a situation where they perceive a threat or they don't perceive a threat reasonably.
You mentioned earlier that based on the Supreme Court, the federal Supreme Court and state Supreme Court, officers are allowed to be mistaken.
That is correct. It's written right into the standard.
And the analysis of that mistaken is one of reasonableness?
That's what it is.
Okay. All right, I want to get to your analysis of the events that happened that evening, starting with the call or the dispatch that Officer Coy was sent on.
Okay. So Officer Coy and Officer Detweiler were dispatched at 1054 Oberlin Drive. It first came out, I think, as a 1016, which in Columbus Division of Police lingo 10 code is a disturbance. Mm-hmm. It's a very general description of things. In this case, the car was there and it was starting and turning off. So they knew somebody was in the car to be able to accomplish that. So they responded to 1054 Oberlin. Officer Coy got there first.
Mr. Scanlon, I apologize for interrupting. With regards to the call itself, a suspicious car or vehicle, in and of that self, any important in your analysis?
No, I mean, the significance of that is it's 1:30 or so in the morning. Of course, obviously very dark. It's a very cold night. So it by itself, not a big deal, not a serious concern. It's just one of those things that the officer plants in their head to combine with anything else that might be alerting to them.
Upon arriving, Officer Coy arriving at 1054 Oberlin, what fact did you then examine in your analysis?
I believe Officer Coy then saw a vehicle in fairly close proximity and got out of his cruiser and started toward that to see what might be going on. The caller, though, from 1054 came outside and said, "Hey, just so you know, that's not the car in question. The car in question has moved, and that car had moved down 2 houses down the street.
In your analysis, the fact that the car was initially there and then had moved, does that factor into your analysis?
Just another indicator that something's a little bit odd, right? So they were in one place and now they've moved down 2 houses, and it's just something else to store in there. Like I said, most of these indicators on their own is of no significance, but as they build upon each other to make it more significant as it moves forward.
With regards to your review of the photographs that area, were there any cars parked in front of 1062 that you saw in any of the photographs?
I saw none parked in front or in the driveway of 1062.
What fact or what incident did you then analyze in your process?
Well, Officer Coy drove down past 1062 to 1070 to where the vehicle was parked with who later would be identified as Mr. Hill in the driver's seat. That car, though, was parked not in front of 1062 and at the furthest western edge of the property line of 1070. Officer Coy pulled up, kind of canted his car a little bit offset as just a good tactic so he can have some cover walking up to the vehicle in question, and he approached that car.
So at this point, the car's not doing anything illegal?
No.
Okay. There's no criminal offense?
No, sir.
Okay. What did you factor next into your analysis, sir?
Well, as it was his mandate, Officer Coy had to go up and make contact with whoever was in that vehicle, so he did. And as he got there, he came in contact with Mr. Hill, who at that time, Mr. Hill had dropped the window and was kind of waiting for him and had a cell phone up in the window and his left arm over this way is the way Officer Coy described it. And so the screen was facing Officer Coy, and Mr. Hill said something to the effect, "I'm waiting for someone."
Anything about that individual situation concern you?
Not terribly significant, but again, just another thing to put in your memory bank there, because of course it was, Officer Coy said that that Mr. Hill was acting a little jittery, a little bit nervous, was kind of dismissive, didn't want to continue the conversation to further explain why he was there. That's a little odd because, of course, it's 1:30 in the morning, you've been parked at one place and now another, and to not fully engage an officer and try to plead your case for why you're there in suspicious would get the attention of a lot of officers.
Okay. But at the same time, Officer Coy, what was your understanding of what he said or did at that point?
I believe Officer Coy just explained to Mr. Hill that, okay, just so you know, we got a call about you being out here in the car driving, so that's fine. And he's basically returned to his cruiser.
Officer, is there a mandate that Officer Coy has to get his name and ID or anything at that point in time?
Well, no.
Okay. No. So again, nothing criminal about what Mr. Hill is doing at this point, or nothing with regards to a reasonable articulable suspicion of an offense occurring?
That's correct. No, there's none of that. So it's just, again, just doing his due diligence and what is required to do, which is make contact.
Okay. And then the next step in your analysis, sir.
Officer Coy was returning to his vehicle. Mr. Hill's, the windows on the car, according to Officer Coy, were a little tinted, but he looked in and he knew there was items in the car, an abundance of items. Again, not a big deal, just something else to consider. But Officer Coy went back to his cruiser and sat in the driver's seat, but he purposely left his door open. It was very cold that night, but purposely left the door open, which is a good tactic because it's not knowing what's going on, knowing it's kind of a little bit of a suspicious activity here, that he wants to at least be ready in case Mr. Hill was to get out of the car and approach him again. You're better standing up than you are sitting down in a cruiser.
Okay. How about the fact of running the tag?
Yeah, so running a tag would just be another course in the action, just to see where is the car stolen, does it come back to this area?
And what was your understanding of where the tag came back to?
I'm not sure where it came back to, but it was not Oberlin Drive. It was not that area.
Again, anything significant about that individual aspect?
No, it's just another thing. There's nothing terribly significant, but it's something that the officer would just keep in the back of their mind.
What event did you then analyze next, sir?
As Officer Coy was sitting in his car, as Officer Coy was getting out of his car, Mr. Hill was then, I don't know, at some point, minutes later, got out of his vehicle and walked behind his car in front of Officer Coy. Officer Coy immediately got out of his car and just stood there by the car, and Mr. Hill passed in front of him without saying any words at all and walked up on the sidewalk, but didn't walk up to 1070. He went behind Officer Coy's vehicle and walked up to 1062 to the front door.
Nothing illegal about that.
Nothing illegal.
But again, parked in front of 1070, parked in front of 1054, not adding up, right?
It's something that an officer would take note of.
Okay. What happens next, sir? In your analysis, I apologize.
Mr. Hill walks up to the front door. He knocks on the door hard, and no one comes to the door, and
Consideration?
no lights come on in the house.
Is that an observation, or is that important in the analysis?
Yeah, again, we're just kind of adding to things that just seem a little bit suspicious, that aren't quite right. I mean, in the mind of an officer there. No lights come on. You're apparently waiting for someone to come out of the house, yet no one comes to the door and no lights come on in the house. He knocked a second time, several times, and still the same result. No one came to the door and no lights came on.
The next step in your analysis, sir.
Mr. Hill returns to his vehicle, walks in front of Officer Coy again without making eye contact again, and goes around to the driver's side, opens the door, and rummages through the vehicle to some extent. And it's unknown to Officer Coy at that time whether he retrieved something, Mr. Hill retrieved something, or didn't.
Why is that important in an analysis of someone reaching into a car?
Well, I mean, along with other suspicious activity, that's something that you would want to register, just because there can be weapons in a car. And so you want to make sure that you are watching the individual. That's why Officer Coy stood up beside the vehicle as Mr. Hill was walking back and forth.
Nothing illegal, though, about going into a car or looking for something?
Nope, no probable cause to take any enforcement action on that.
Okay. Building on reasonable suspicion?
Certainly is.
Okay. The next step in your analysis, sir.
At that time, Mr. Hill then walks behind his vehicle again in front of Officer Coy again, and now and makes no eye contact, and Officer Coy at this point goes, "Hey, what's going on?" Something to that effect. He asked him, "What's going on?" Okay. And Mr. Hill didn't respond. Okay. He didn't make eye contact.
Is that something that officers are trained to observe?
Yeah, but actions and inactions and verbal and nonverbal cues, and yes, you're supposed to pay attention to that.
Mr. Hill's under no legal obligation to answer him.
No, he's not.
Okay. But again, a factor to consider.
Yes, sir.
What happens next in your analysis, sir?
So Mr. Hill walks back up toward the 1062 residence and kind of out of Officer Coy's view, and that's exactly the time that Officer Detweiler pulled up.
Before we get to Officer Detweiler, what occurs, based on your review of the evidence, what occurs between Mr. Hill and Adam with regards to, are there any, I'm sorry, are there any looks or?
No, that's right. Yeah, so as he was walking away from Officer Coy and he got to the sidewalk and approached the driveway, Officer Coy saw Mr. Hill doing a few target glances over his shoulder at Officer Coy.
You use the term target glance. What's a target glance in training of police officers?
It's just when you're dealing with a subject, especially if they don't respond to any verbal cues, and if they don't make eye contact when they go right by you, but they get past you and then they decide to turn and look back. To target glance means basically size you up or try to determine what you're doing. They want to know what you're doing. Are you following them or are you not? It's just a term. It can be innocent enough, but it's a danger cue based on other suspicious activities that you don't want to ignore, just in case it becomes more of a threat.
You use the term danger cue. Explain that to the ladies and gentlemen of the jury.
It's just a number of different things that can be done by body language, the run itself, the movement of people, their verbal engagement with you or their lack of verbal engagement, everything that it can just be suspicious. One thing on its own maybe is insignificant. Maybe 3 or 4 things can be insignificant. but they tend, in the mind of a reasonable officer, they tend to build as they go on.
Are officers trained on danger cues?
They are.
So is it fair to say a natural movement by a person can be a danger cue?
It can be.
Our officers have the ability to determine what the intent of someone is looking into their mind about a physical action?
There's no way to determine intent of an individual. All you can do is base your decisions and your opinions and your threat cues on the actions of people or non-actions.
Are you precluded in your analysis of these events from looking into the intent of Andre Hill?
I am.
Why, sir?
I can't possibly know. All I can base it on is what the actions were of that individual.
So, and I apologize for cutting you off. You said at that point in time, Officer Coy loses track of where Mr. Hill is, and that's when Officer Detweiler pulls up.
Officer Detweiler pulled up and parked and approached Officer Coy.
Their interaction, what goes into your analysis, or what did you notice in the analysis of their interaction?
Something was said by Officer Coy to the effect, something's just not adding up. Of course, that didn't have to be too fully explained to Officer Detweiler because she knew she was dispatched to 1054 Oberlin. She got to that location coming from the east and realized they're not there, that this scene has now moved 2 doors down. So that would be significant in her mind. She knew it was a suspicious car, suspicious person, run. So that entered into it. And she knew when she pulled up, she could see Mr. Hill walking up the driveway. And so when Officer Coy indicated, hey, something's not adding up, she knew, well, we got to make contact. Obviously, we got reasonable suspicion.
At this point in time, there's reasonable suspicion for both Officer Coy and Officer Detweiler.
Oh, yes.
What goes into your analysis next, sir?
They start walking up. Officer Detweiler, according to Officer Coy's body-worn camera, as she starts moving up the driveway of 1062, she pulls her firearm in a low ready position. It appeared to be to me.
Why is that important, sir?
Well, she understood the significance, and I mean, it's going on 2 o'clock in the morning. They're looking for somebody who is acting suspiciously, and very soon, I don't know if it was before or after she pulled her weapon, to be honest with you, she noticed that the garage door of 1062 was up, but there were no lights on in it.
Why does that factor into your analysis, sir?
Well, again, this behavior is odd. There's, of course, and then you start thinking, you know, is this a theft in progress? Is this a burglary? Is this something more serious than that? You have to start wondering at that hour of the night, based on all this information, and a person walked away and now you don't know where they are. You have to consider that.
You can have a burglar in a garage, correct?
Certainly.
That's part of the definition?
Yes, sir.
So with regards to why the significance of the garage door open? Did that play a factor in your analysis?
Well, we know it was open, but we also know that there wasn't any light on inside. Now, I'm not saying that all lights work in garages, but people don't normally leave their garages open at 2 in the morning. That's been my experience, at least on patrolling the streets. And along with that, oftentimes if you walk into a garage, you trigger a beam that will turn on a light. Doesn't always happen, but it's pretty normal. And so they don't know where Mr. Hill's gone. And I think Officer Coy indicated he thought he'd probably walk around to the back side of the house.
Okay. So the analysis that the fact that the garage door is open and it's dark comes into your analysis.
It's just one more thing. It just keeps building. Yes.
Okay. Describe for ladies and gentlemen of the jury your next fact that you analyze with regards to their approach of the garage.
So Officer Detweiler walks up the driveway of 1062, and she's kind of off to the right a bit. And Officer Coy walks up the driveway of 1070, which gives him a better angle. And of course, officers just know to work together that way, where there's no reason walking up side by side. You might as well split the difference so you can, what they call, pie off an area. So Officer Detweiler will be able to see more of an angle to the left, and Officer Coy will be able to see more to the right. And again, not knowing whether he went around to the back, Mr. Hill went around to the back of the house or someplace else, this gives them better coverage in how they can approach.
At some point, they're both on the driveway proceeding towards the garage.
Yes.
What's the next significant event that you analyzed in the garage?
Well, as Officer Coy comes around some brush and trees. He's looking into the garage, and he's decides to shine his light in there, as does Officer Detweiler, and at some point, they can see Mr. Hill back there, plus his screen on his cell phone, I think, is lit up. But
Anything with regards to where the person was in the garage that factored into your analysis?
yeah, he's as deep as you can get into the garage. It's as dark as it can be back there. Never could have seen anybody back there without some illumination. So the question comes in, why are they there? Of course, the location would be a great place to hide, but it would also be a place where you would normally have a door on an attached garage to go into a residence. They're deep on the right, so that entered into my mind.
At this point, is there a mandate to investigate?
Oh, there's absolutely a mandate to investigate. So the way I explain it to people sometimes on, well, did they really need to go talk to this person or that person or whatever, envision this being, I know if it's my house, but if it's your house, but if you have someone who's parked at one location and then parks down at another location and then goes to the house in between, and you've had this encounter that Officer Coy's had with that person, and then they walk up to your house and your garage door's open and they disappear. I want someone to investigate that. It's a mandate. If you don't do that as an officer, it's dereliction of duty.
What happens next, sir, with regards to your analysis?
They spot, Officer Detweiler and Officer Coy, I think, spot an illuminated Mr. Hill in the depth of the garage. And Officer Coy says something to the effect, hey, what's going on? Show yourself.
Come out here?
Come out here. I don't know what the exact words were, but
In police world, what does show yourself mean?
it means show yourself, show all of yourself. It doesn't mean show part of yourself, but it means show yourself.
Based on your review of the information, did Mr. Hill have his left hand up?
He had his left hand up about shoulder height with his cell phone lit up in it.
Based on your training and the training that you do, can that be a distraction tactic?
That's what we would explain to somebody, is that they don't get focused on one hand and not see the other hand, because sometimes it's a diversion.
Okay. What about your analysis of what Mr. Coy could see with regards to the right side of Andre Hill's body?
Well, he couldn't see the right side of his body because as he started to exit the garage, Mr. Hill did what we call a blading move, which is led out of the garage with his left elbow, left shoulder, had the cell phone up, but at about a 60-degree angle where his right hand was back behind his right thigh, right hip area.
And our officers trained to observe that?
That's correct. The blading can be it can be nothing, but it can also be an attempt to hide a weapon in the right hand. The arms aren't moving freely. It's odd. It's suspicious when someone approaches you in that way.
In and of itself, blading may be innocent, correct?
It can be.
In a certain context, based on totality of circumstances, can it be an important factor?
Of course.
And is it a potential threat factor?
Certainly is. And again, we're looking at the totality of the circumstances here. So this is just another factor on top of all the ones we just discussed from the time the run was put out.
Officer Coy could have said, hey, show me both your hands.
Could have.
Was there time to do that based on your analysis?
I was struck by how quickly this evolved, because Officer Coy was approaching Mr. Hill as Mr. Hill was approaching him. And so it was just a matter of seconds between that encounter and coming together. So I don't think there was enough time, in my opinion.
Mr. Hill started coming out, so there is some type of compliance.
Oh, there's certainly partial compliance here. Yes, he starts to come out. Now, I don't know how it was going to end up, but yes, certainly he was at least coming back out. He didn't try to hide further into the garage.
Okay. What happens to your analysis with regards to Mr. Hill's motions at that point in time, sir?
As Mr. Hill was approaching, he was kind of sucked up against a vehicle that was in the garage. He was leading with his left shoulder with the cell phone up. His right side of the body was up against the car as he moved down alongside that car. But as he got to the back of the car, to the right rear bumper, is when once he cleared that, the right arm was freed up to, and started to rise.
And that's what Officer Coy believed was a danger, perceived a deadly threat.
That's when he saw what he described to be a silver revolver in Mr. Hill's hand.
Yelling gun, 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 is that a trained tactic?
It is. You want to advise anybody who's around you that you've seen a gun, especially if you're working with a partner, you want to advise them you can see a gun because they very well may not be able to.
The fact that Officer Coy shot and Officer Detweiler didn't shoot, did that come into your analysis?
Only that part made sense to me because if you don't see the threat, you can't fire. You can't. Officer Detweiler would not have been reasonable in shooting her weapon just because Officer Coy did. She didn't see the threat, so it happens all the time in police work where one sees the perceived threat and some don't.
And based on your review of her statement and body-worn camera, could she see the right side of Mr. Hill's body as he came out?
She could not.
The fact that 4 shots or gun, 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 is that based on training and your review of this analysis?
It's exactly what we would train for at the academy or in firearms training. You recognize a threat, you draw your weapon, and you fire until the threat is gone. It can be one shot, it can be all the shots in the magazine, but once the person goes down and it's perceived to be the threat is gone at that point, then you stop shooting.
Okay. And is a person still potentially a threat even if they're on the ground if there's a belief that they have a weapon?
Oh, absolutely. If you can't see the hands and if you can't see the weapon, then it's still in play. Don't necessarily have to continue shooting, but you have to be very cautious, as Officer Coy was, in approaching that person.
What did Officer Coy, based on your analysis, his interaction with Officer Detweiler there, was that important in your analysis?
Officer Coy became very vocal and very insistent upon Officer Detweiler, do not approach. We can't see the hands, still got the gun, and made that a point to caution her away from that because she hadn't seen what she thought was a gun, so he had to advise her of that. Stepping
back to fire, explain to the ladies and gentlemen of the jury what that means based on training.
I'm sorry, ask me that again.
Officer Coy stepping back to fire or taking a position to fire. Why is that important in your analysis, sir?
Well, like I said before, of course, the garage was inset between 2 walls, the one on 1062 that came out and the one on 1070. So you want to get offline. You want to move. You don't want to be a stationary target. Going side to side might not be an option, but going backwards may be a good option just to create distance. And so that's what he did. He just shot it looked like he was moving very quickly down by the vibration of the body-worn camera on his chest.
And turn the body-worn camera on.
I'm sorry?
And then turn the body-worn
camera. Yes, he did
camera.
after the shot. He did. And then it had a 60-second look back.
Subsequently, sir, you had a chance to view the property out of BCI, correct?
I did.
Did you review the keys in this situation?
I did.
You were presented a picture of the keys initially, correct?
I was, and then I requested to see them because, again, the pictures just don't do it for me. I can make a much better decision if I can actually see them and hold them, if I'm allowed to hold them, which I was.
But you made your opinion, though, before you went and got the keys. Okay.
Yes.
When you observe the keys, what's the primary color of the keys?
Silver.
What's the primary source, or what's the primary makeup of the keys?
Metal.
And looking at a silver revolver, what's the primary color of a revolver?
Silver.
What's the primary makeup of the material?
Metal.
Sir, you based your opinion on whether or not Adam Coy's actions were within and accordance with recognized police practices and procedures, correct?
That's true.
Based on everything you reviewed and your testimony, are you telling ladies and gentlemen of the jury that that is correct?
That is absolutely correct.
All right. May I have a moment, Your Honor?
You may.
Thank goodness I asked. Sir, I'm going to take you back. As Officer Coy and Officer Detweiler approached, to investigate based on reasonable suspicion. Would a police tactic be to use the microphone to tell the rest of the force what they're doing?
No, no.
Would you ever get on the microphone and say, hey, I'm walking up a driveway to investigate what's going on to the rest of the police force?
I wouldn't, no.
Have you ever done that in your
never done it.
34 years?
I've not.
Okay. With regards to again, as Officer Coy and Detlower approach, would you ever envision a scenario where, in this scenario, the SWAT should be called?
No, I was full-time Columbus Division of Police SWAT for 19 years, and this is a patrol run. This is there still was no offense. There was no barricade or hostage situation or anything of that sort. So no, it was not a SWAT call.
Okay. You had the opportunity to review the prosecution's expert, Mr. Stoughton's report, correct?
Yes.
Do you agree with that report, sir?
Much of it I don't.
Why?
I believe he's trying to create his own standard, and there's only one standard by which officers are judged in these situations, and I don't think he gave it much notice. I do believe, though, that he did indicate that the reasonableness of a shooting can happen even though the officer is mistaken. So I think he touched on that.
So you believe in, you agree with part of it, you disagree with part of it?
That's correct.
Is that uncommon among experts on different sides?
No, I'd say it's pretty common.
Okay, all right. Mr. Scanlon, thank you for being here. That's all the questions I have for you right now. Thank you.
Thank you, Mr. Collins. Okay, ladies and gentlemen, we're going to take our morning break at this time. If I can get you back in the jury room at 10:30. At 10:30. Again, remember the admonitions that I've given you with respect to discussing this case among yourselves or with anyone else. All rise for the jury. Anything we need to get on the record before bringing the jurors in? Nothing from the state, Your Honor. All right, Mrs. Harper. All rise for the jury. Be seated, ladies and gentlemen. Cross-examination.
Mr. Scanlon, good morning.
Good morning.
You were a Columbus police officer for how long?
33 years.
33 years. So when was the last time you were with the Columbus Division of Police?
Columbus Division of Police, I retired in 2011, and then the company, North American SWAT Training Association, where we did training, that ended in 2021.
Okay. So 2011?
2011, I was retired from the Columbus Division of Police, yes.
Okay, thank you. And isn't it part of the mission of the Columbus Division of Police to safeguard the lives, property, and rights of all? That'd be
Yes.
it. Okay. You stated that you testified in criminal cases.
Yes.
How many criminal cases have you testified here in Ohio?
Can I review my CV, sir?
Sure. And to be clear, I'm not looking for ones that you've worked on, just ones that you have actually testified in court. Yes, sir.
That'd be 6.
Okay. 6 cases,
Yes.
and all of those cases have been on the police officer's behalf, correct?
Well, that's true. I've offered to testify against police officers in criminal cases, but as recently as a year ago, August, but I was not taken up on the offer.
So you've testified 6 times in favor of police officers, and I think you answered the next question 0 times for the other side, even though you've offered.
I've offered, but no, I have not testified against. I've never been retained to do that.
Okay. Just to be clear, you've never been a lawyer, have you?
No, sir.
Never practiced law in Ohio or any other state?
No, sir.
And you said something with respect to Mr. Collins's question. I just want to make sure you're aware that the standard of an officer-involved shooting for this case is going to come from the court, correct? You are aware of that?
Yes, sir.
You also stated that reasonable minds may come to different conclusions than what you have come to in your analysis and report. You would agree with that?
It doesn't always happen, but it can.
Okay. And that's actually happened in some of your trials that you've been involved with, correct?
It has.
Can you talk about the use of force continuum, please?
Well, they can change from agency to agency. It's normally a 1 through 8 or 1 through 10, basically starting off with a 0, and it can be anything from officer presence up a number of different notches to actually use of deadly force.
Okay. So a use of force continuum is basically a scale of the type of force that a police officer is permitted to use in different circumstances, correct?
That's right. You don't have to go through all the different stages to get to the ultimate one, but yes.
Okay. So the ultimate one is use of deadly force?
Yes, sir. You can go straight to that. Mm-hmm.
And the lowest one is what? Verbal command or officer presence?
Yeah, officer presence or verbal command. Mm-hmm.
Okay. In what situation would officer presence be appropriate?
Oh, when you have to make contact with an individual based on reasonable suspicion, maybe, or just showing up at a run.
Okay. And I know you said that it changes from agency to agency, but since you're familiar with Columbus Police Department, we can use Columbus Police Department. Talk about some of the items in the middle. Some, we've got use of deadly force on one end and officer presence on the other.
So it can be use of mace, be a lower one, use of open hand strike. It can be a use of a baton. It can be use of a canine, all the way up to multiple strikes or kicks, and then it can get to a point of use of deadly force.
Okay, and you stated before, just a moment ago, that you don't have to necessarily start from the bottom and work your way up. It depends on the threat that is present, correct?
That's very true.
What's your definition of a threat, Mr. Scanlon?
Oh, it can be a number of different things. It can be anything that raises the fear level in the mind of an officer. It can be a threat indicator as simple as somebody's body language. It can be failing to stop, failing to comply.
I'm sorry, you may not have understood my question. I'm looking for a Finish answering the question, Your Honor? Well, he's not answering my question.
He's restating his question.
Thank you, Your Honor. I'm looking for the definition of an actual threat, not things that can be threat indicators, but do you have a definition of what a threat is?
In short, it would be anything that would raise the fear level in the mind of an officer, a reasonable officer. So it could be balling up of the fists, for instance. It could be hands being concealed. It can be hands in the pocket. It can be verbal cues, nonverbal cues, a number of different things.
But you would agree with me, Mr. Scanlon, that fear does not equate to a threat.
No, the fear is the result of a threat.
Couldn't I be afraid of something and there be no threat present?
Well, there's perceived threat and actual threat. There's an actual threat would be someone pointing a gun and shooting at you, or striking you in the head with an object. So there's a number of different types of threats.
Okay, let me use an example. Let's say I'm a small, petite person in an elevator, and a big, strong, burly person gets on the elevator with me. I may be afraid, but that doesn't mean that this person is a threat to me, does it?
No, if they haven't shown any threat, I see where you could be fearful and not have a threat.
Okay, right. There needs to be something else to comprise a threat.
Normally, that would be the case, I believe, yes.
Okay, so if that person hasn't said anything rude to me or shown me a weapon or indicated that they were going to do harm, those are things that I would want to be looking for to determine whether I'm just fearful or that I'm fearful and there's a threat. You would agree with me, correct?
Well, to some extent. I mean, body language can do that. If somebody gets onto that elevator and they just happen to be very large, maybe it's not enough. But if they get on the elevator and they have their hand tucked down in a waistband, or they have their hand concealed, or if they're doing something body language-wise, that may justify that fear.
Okay. But you would agree with me that fear in of itself does not equate to a threat?
Fear is normally the result of a threat, or a perceived threat.
So when we're looking at these cues that you talked about, pre-attack indicators, are they also sometimes called that, or do you not use that term?
They can be. I mean, there's threat indicators, there's danger cues. People use different terminology, but just things that heighten the alert level and or fear of the officer.
And so these danger cues, oftentimes, a lot of them can be just normal body movement. Isn't that correct?
That can be the case.
And I believe it's your testimony that it is that officer's perception of that body movement that constitutes the indicator, correct?
Yeah, or that of a reasonable officer, yes.
Can you name off some pre-attack or fear indicators?
Well, it can be somebody who is not willing to engage, or somebody who engaged verbally in a violent way. It can be someone who's balling up their fists. It can be somebody who's approaching an officer with their hand concealed. Those kind of things.
Can pretty much be anything, correct?
Well, not really, but it's normally the culmination of a number of different ones rather than just one event. But yeah, it can be whatever's would be reasonable in the eyes of an officer on scene.
Okay, can you talk to me about a body movement or position that wouldn't be a pre-attack indicator under any circumstance?
Right, so for instance, even with all the other indicators that were present here, it's my opinion that had Mr. Hill walked out with both hands, empty hands exposed, that would not be a threat indicator.
So that's important to you in analyzing this situation, that Mr. Hill did not walk out of the garage with both hands raised. Is that accurate?
No, you asked me if what would not be an indicator, and that would have definitely not been a threat indicator had Mr. Hill approached Officer Coy with both his hands visible with nothing in the hands. Then that would not have been a threat indicator.
Okay, so I guess my next question is, that sounds to me like that is important in your analysis. Is it important in your analysis?
What's important in my analysis is that didn't happen, but what happened in replace of that was he approached Officer Coy with his hand behind his right thigh and bladed.
Okay. You mentioned that you took Coy's statement, correct? You read his statement?
I did.
And you read his interview with the investigators from BCI?
Yes, sir.
And you took that into account when writing your analysis?
That and everything else in the evidence, yes.
Correct, yeah. You haven't spoken with Mr. Coy about this incident?
I have not.
And you haven't watched any of his testimony in this trial? Okay. So if he said something different than what was contained in those items, that could possibly change your opinion, depending on what it is.
It's hard to know. Well, I can't play the hypothetical here, but I mean, I have no idea what you're talking about.
Well, let me ask this question again. If in fact he testified to or stated something different than what is contained in his written statement and his interview with the police, that could possibly change your analysis, correct?
Yeah, I hate to be non-responsive, but I honestly would have no idea. But if it's presented to me, I'd be glad to look at it.
So you don't know if there's anything that Coy could have said or done differently that would change your analysis?
I have no way of knowing one way or the other because I have no idea what the statement might be.
You do admit in your report, and I believe in things that you've testified to today, that a lot of the things that Mr. Hill did could be interpreted as also consistent with waiting on someone.
Oh, that's true, especially at the beginning.
So I'm going to circle back to this point. Did you or did you not take Officer Coy's analysis, his interviews into consideration when you made your analysis?
I did consider him, yes.
So you considered his words in formulating your opinion?
I did, along with the areas of that statement that were corroborated by the caller, by Officer Detweiler, by body-worn camera, by evidence.
Okay. So but yet still, you're not able to say if his statement here in court, if it's different than what you read, you can't say if that would make any difference at all.
Objection, Your Honor, asked and answered, and he answered he can't comment unless he knows what the difference is.
Well, overruled.
Thank you, Your Honor.
Yes, I have no idea what he said, so I can't really say one way or the other what my opinion would be of what he said.
I'm not asking you about what your opinion would be. I'm asking, would it have an effect on your analysis?
I don't know.
When an officer is involved in an officer-involved shooting, they're responsible for each round that comes out of their gun, correct?
That's true.
And you mentioned the OODA loop principle. Can you say what that is again?
Yes, so it's OODA. The first O stands for observe. The second O stands for orient, as in orient yourself to it. The D stands for decide, and the A stands for act.
Okay. And that needs to be applied in every use of force, correct?
No. That's just a concept to explain and train officers. It's a tool in training officers how, concerning the fact that the actions of a subject will be faster than the officer's reaction to it. It's just a tool in training them and making them aware of how far behind the curve they're going to be time-wise.
But officers are trained to, with the use of force continuum, they're trained to look at that application of use of force and determine whether they need to ratchet it up or ratchet it down, correct?
That I don't understand the question.
If you as an officer are apprehending a suspect who, let's say, robbed a bank, for instance, and then they have a weapon, would deadly force be appropriate in that situation?
Not unless they're threatening me with it, not unless I perceive a life-threatening situation.
Okay. So just because an individual has a gun in their hand doesn't equate to using deadly force, is that correct?
No, like I said before, the way the hand is presented is sometimes even more significant than what's in the hand.
Okay. So just because someone has a gun in their hand doesn't require deadly force?
Not necessarily.
Okay. And also, if deadly force is appropriate at a particular situation, and then the individual surrenders, deadly force, therefore, is not applicable. Is that correct?
If you could just say it one more time, I had trouble following that.
Yes, sorry, you may have been distracted. If an individual is performing something and the officer perceives deadly force is necessary, but deadly force is not used on that individual, and then they surrender.
Then the threat is gone, and you don't react beyond the time that someone has, you only react until the threat is eliminated.
Okay. So again, at some point, when you notice a deadly force, your response of deadly force may be appropriate, but once that goes away, your response needs to go down, correct?
I would agree with that.
Okay. And that happens at every step of the way in a use of force encounter, doesn't it? Sometimes you may need to ratchet up your use of force, and sometimes you may need to ratchet it back.
Based on the perceived threat by the subject you're encountering, yes.
Okay. Because sometimes a officer presence will be enough to stop a threat or to stop the possibility of criminal activity. Sometimes it won't be enough. You'd agree with me, right?
Yes, or the perceived threat. I mean, criminal activity may or may not be present in a situation where there's force used.
Okay. So you would agree with me that just because there's criminal activity does not also equate to a threat?
No, it does not.
Someone could be shoplifting from Walmart and doesn't necessarily mean that they're a threat.
That's true.
I think you stated it well multiple times for defense counsel when he was questioning you. You stated that an officer is allowed to make a mistake as long as that mistake is reasonable, correct?
That's correct.
Key word being reasonable, right?
Yes, sir.
So just because an officer makes a mistake, that's not the end of the story, is it?
No, the mistake has to be objectively reasonable.
Objectively reasonable. That's the same with possible remorse or sorrow after the incident, correct?
What's the same?
That we look at whether the actions were objectively reasonable.
I'm not following how that equates.
I'll set it up better. Let's say an officer uses force and they feel bad because of the amount of force that they used. Just because they feel bad because they used force, it does not necessarily excuse the force that was used, does it?
No, I mean, it's a normal reaction from my experience, what officers feel after the fact, especially if they realize they've made a mistake, certainly, but it doesn't equate to the actual use of force or the reasonableness behind it.
Okay, so that's essentially irrelevant when we're determining whether that use of force was objectively reasonable. Is that correct?
An officer may show remorse and may not, may outwardly become incapacitated emotionally and physically or not.
Okay. So it has no bearing on whether that use of force was objectively reasonable, correct?
Yeah, I don't think it has a bearing on it.
When we look at 2020 hindsight, you said you studied court cases and things like that.
I have.
So when we look at 2020 hindsight, aren't we also looking at individuals who may, for instance, go into a bank with something under their shirt, having it pointed at the teller, looking like a gun, right? And then the officer uses deadly force, thought the guy had a gun because it looked like it because it was protruding out of his jacket. Those are those type of situations, correct, as well?
I've heard of those kind of situations, and in relation to what, though?
We're looking at we're prohibited from looking at 2020 hindsight, the fact that that individual did not actually have a gun.
Right. 2020 hindsight relates to the fact that you have to judge an officer based on what was in the mind at the time they fired the rounds, and that could be everything in this case from the time they were dispatched to the run to the time Officer Coy fired his weapon, but nothing beyond that or anything that's learned beyond that.
Right, so we're looking at the totality of the circumstances and what the officer knew at that time, correct?
Yes, sir.
One last question, Mr. Scanlon. You stated that there wasn't enough time for Mr. Coy to say, "Show me your hands."
I said that it took, in the way I reviewed it a number of different times on the body-worn camera video, Mr. Hill and Officer Coy were approaching themselves simultaneously, and it's just a matter of seconds. And so I don't think there was enough time to say a lot of things. A lot of things could have been said, but weren't, but timing was going to be critical.
Okay. But you do agree with me that Officer Detweiler and Mr. Coy walked all the way up the driveway, correct?
I believe they got up to the very top of the driveway.
Yes. And they could have, I guess Mr. Coy could have yelled, "Show me your hands." At the same time, he said, "Show yourself," correct?
Well, that I'm not sure about, because I know that Officer Detweiler was aware of the open garage prior, I think, to Officer Coy, because Officer Coy came from the southwest corner, basically, of that garage area. And so I don't know that they saw and felt things at the same time.
So it's your testimony here today that you do not believe that Mr. Coy could have said, "Show me your hands"?
Well, no, I'm not saying he couldn't have. I'm not playing 20/20 hindsight on what he could have, should have, would have done.
Okay. Thank you. I have no further questions.
Thank you, Mr. Pearson. Redirect?
Thank you. May I proceed, Your Honor?
You may.
Thank you so much. Mr. Scanlon, I want to start where Mr. Pearson left off. Okay?
Yes, sir.
Based on your analysis, training, expertise, and the case law and stuff, does the Supreme Court of the United States require an officer to say, "Show me your hands," before they perceive a deadly threat and fire their weapon?
No, sir.
Your Honor.
Rephrase the question.
Are officers required to say, "Show your hands," before they use deadly force?
No, sir.
Where does that come from?
I don't know where that came from, but I mean, the officers may or may not have time to give warnings or directions to an individual who they perceive reasonably to be posing an imminent deadly threat.
Has the Supreme Court of the United States made it a condition before you use deadly force that you have to say words?
Objection, Your Honor.
All right. Excuse us one moment, ladies and gentlemen. Please approach counsel. Thank you, ladies and gentlemen. You may be seated. All right, the objection's overruled.
Thank you, Your Honor. May I proceed?
Okay.
Mr. Scanlon, based on the training that you've had, based on the training that you've done, based on your review of case law from the Supreme Court with regards to use of force cases, is there any requirement that an officer must use verbal orders before using deadly threat, or before using deadly force?
No.
And that's based on nationally recognized police practices, correct?
It is.
And based off of Supreme Court cases.
Yes, sir.
I want to clear a couple things up here, Mr. Scanlon. If an officer observes an immediate perceived threat, what are they trained to do?
They're trained to stop the threat.
Are they trained to take a second and see if that immediate perceived threat becomes a deadly threat?
No.
Why not?
Again, action beats reaction. If they perceive a lethal threat, a reasonably perceived lethal threat, they're trained to respond to that with lethal force.
Okay. Mr. Pearson asked you numerous questions about if Mr. Coy said something different in his testimony versus his written statement versus his tape statement, would that affect your opinion? You remember those types of questions?
Yes, sir.
So if Mr. Coy testified that that he didn't see the text, the words on the text as the phone was shown to him, but that was told to him, but in his written statement, he said he could see the words, and his oral statement, would that change your opinion on the use of force in this case?
No.
If Mr. Coy testified that he went around one side of the tree and you believe that he went around a different side of the tree, would that change your opinion in this course of the use of force?
No, sir.
If Mr. Coy testified on his cross-examination to Mr. Pearson that when he was, he saw Mr. Hill put the phone out, make an X, and his left hand goes towards to the right thigh, and then didn't say in his taped interview that his elbow was on the window that was rolled down. Would that change your opinion in this case, sir?
No, sir.
May I have a moment, Your Honor?
You may.
Mr. Scanlon, thank you.
Thank you.
Thank you, Mr. Collins. Recross?
Mr. Scanlon, thank you for your testimony today. Your Honor, I have no questions.
All right, thank you.
Thank you.
All right, you can step down.
Thank you, Your Honor.
All right. Counsel, please. All right, ladies and gentlemen, we're going to have a short day today. Actually, this is all the testimony that you're going to hear today. So you're going to be free this afternoon. Your services will not be needed. Again, the admonitions that I've given you still apply. You've not heard all the evidence in this case, and obviously you've not received the instructions of law from me. Tomorrow morning, again, need you here before 9 a.m. We'll try to start at as close to that time as we can. So please, everyone, enjoy your afternoon. Yes. Oh, okay. Okay, yeah, let's go ahead and get that on the record. I'm sorry.
Would you like to inquire?
Yeah. So anything else on behalf of the defense?
No, Your Honor. With the presentation of Mr. Scanlon, this defense would rest with the exception of submitting a exhibit.
Okay, thank you. Thank you, Mr. Collins. All right. Despite the fact that the defense has rested, you still have not heard all the evidence in this case. Again, need you here tomorrow morning before 9 a.m. We'll try to get started as close to that time as we can. The admonitions still apply, and please have a safe trip home today and a safe trip back here tomorrow morning. All rise for the jury.